Bonjour. Bonjour aux membres de la communauté du monde. Nous souhaitons tous une bonne année 2022. La Cour africaine va procéder ce jour du 10 janvier 2022 au prononcé d'une des décisions qui ne l'avait pas été lors de la dernière session. Je vais laisser la parole au greffe de la Cour pour nous préciser cette décision et nous aurons ensuite à dire le juge qui aura le prononcé cette matinée. Membre du greffe, vous avez la parole.
Merci beaucoup, honorable vice-président, honorable membre de la Cour. Juste pour confirmer ce que vous venez de dire, donc la Cour siège aujourd'hui en session pour délivrer son arrêt dans l'affaire 056-2016 Gozbert Henerico contre la République du Tanzanie. Je vous remercie.
Merci, greffier adjoint. Merci, monsieur Diallo. La décision Gozbert Henerico sera lue ce jour par la juge STELLA ANUKAM. Honorable STELLA ANUKAM, vous avez la parole.
Merci beaucoup, Monsieur le Président. The matter of Gozbert Henerico versus the United Republic of Tanzania, application number 056/2016. The court composed of BLAISE CHIKAYA, Vice President, Ben Kyoko, RAFAÂ Ben ACHO, Susan MENGUE, Theresa MUKAMULISA, Tujaline Aro CHIZUMILA, CHAFIKA BENSAOULA, STELLA I ANUKAM, DUMISANTSEBEZA, MODIBO SACKO, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9 sub 2 of the Rules of Court, hereinafter referred to as the Rules, Justice IMANI D. ABOUD, the President of the Court and a national of Tanzania, did not hear the application. The subject of the application, the facts of the matter. It emerges from the record that on the 27th May of 2008, at Yankaka Baturaj village within Bukama district, Kangara region, following the sale of land by the applicant's brother, Gozbert Henerico, the applicants who had been drinking heavily and inebriated on drugs stormed into the home of his relatives, who were also his neighbors. He injured 3 of them with a banger, a machete, by slashing them on the shoulders, the head and neck and hands. During the attack, he also killed the nephew, the late brother's son, who at that time was being carried by the grandmother on her back. Following the attack, the surviving relatives raised the alarm, compelling the applicant to flee the crime scene to the home of the area chairman, who was also his relative. The applicant was apprehended and taken to the police station while the injured were rushed to the hospital. The applicant was arrested on the 27th of May 2008 and subsequently charged with the offense of murder under criminal case number 7 of 2012 before the High Court of Tanzania at Bukoba. His arraignment was conducted on the 21st May 2012, followed by the preliminary hearing on the 5th of June 2014, and the commencement of the trial on the 16th of February 2015. Subsequently, the High Court convicted the applicant and sentenced him to death by his judgment of the 22nd of April 2015. The applicant appealed his conviction and sentence by filing criminal appeal number 114 of 2016 before the Court of Appeal of Tanzania, sitting at Bukoba. On the 26th of February 2016, the Court of Appeal dismissed his appeal for lack of merit. Alleged violations. The applicant alleges the following. 1, that the respondent violated his right to a fair trial under Article 7 of the Charter when it detained him for an unreasonably long period of time before trying him. When it failed to provide him with effective legal representation. When it failed to acknowledge that his trial was tainted by actual or perceived bias due to the assessors having cross-examined the applicant. And lastly, when the respondent state failed to provide him with adequate access to an interpreter. The applicant also alleges that the respondent state violated his right to life under Article 4 of the Charter upon finding the applicant guilty of murder, when it failed also to take into account his specific circumstances. Also, that the alleged fell outside the narrow category of the most serious offenses to which the death penalty can be lawfully applied. And lastly, that the respondent state imposed a death penalty despite failing to ensure that he received a fair trial. That the respondent state equally violated the African Charter by imposing a capital punishment on him as a mentally ill person and by sentencing him to death by hanging, which is a cruel and inhuman way of administering the death sentence. Prayers of the parties. The applicant prays the court to find that 1, that the respondent has violated the applicant's rights under Articles 4, 5, and 7 of the African Charter. Secondly, that an oral hearing be held in this matter pursuant to Rules 27 and 71 of the Rules of Court. Thirdly, that the respondent take appropriate measures to remedy the violations of the applicant's rights under the African Charter. Fourthly, that the respondent state set aside the death sentence imposed on the applicant and remove him from the death row. Fifthly, that the respondent amend his penal code and related legislation concerning the death sentence to make it compliant with Article 4 of the African Charter. Sixthly, that the respondent release the applicant from prison. And lastly, that the respondent pay reparations to the applicant in such an amount as the court deems fit. The respondent state in turn prays the court to find that 1, that the court is not vested with the jurisdiction to adjudicate over the application. Secondly, that the application has not met the admissibility requirements stipulated under Rule 40 sub 5 of the Rules of Court. Thirdly, that the application be declared inadmissible. Fourthly, that the respondent has not violated Article 1 of the African Charter. Fifthly, that the respondent has not violated Articles 3 sub 1 and sub 2 of the African Charter on the applicant's right to equality before the law and equal protection of the law. Fourthly, that the respondent has not violated Article 5 of the African Charter on the applicant's right to dignity. Next, that the applicant has not violated Article 6 of the African Charter on the applicant's person. The court finds that the respondent state has not violated on the applicant's right to have it, has not violated Article 9.1 of the African Charter on the applicant's right to receive information. In addition, that there are no errors in the judgment of the Court of Appeal which resulted into miscarriage of justice. That also the respondent proved his case beyond a reasonable doubt against the applicant. Also, that the evidence adduced against the applicant was credible and reliable. In addition, that the High Court and the Court of Appeal complied with the laws in believing and acting on the evidence of the prosecution. In addition, that the High Court and the Court of Appeal properly evaluated the defense of the applicant. In addition, that the application be dismissed in its entirety for lack of merit, and the application be dismissed with cost. I'll now move to the operative part of the judgment. After deliberation, and for these reasons, the court unanimously on jurisdiction dismisses the objection to its material jurisdiction. The court declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares that the application is admissible. On merits, finds that the respondent state has not violated the applicant's rights to a fair trial, protected under Article 7, sub 1C of the Charter, as read together with Article 14, sub 3D of the ICCPR, with regard to the provision of effective free legal assistance. Equally on merits, the court finds that the respondent state has not violated the applicant's right to a fair trial, protected under Article 7.1c of the Charter, with regard to the provision of an interpreter. The court equally finds that the respondent state has not violated the applicant's right to a fair trial, protected under Article 7 sub 1 sub c of the Charter, with regards to the right to have his cause heard by a competent court or tribunal. The court also finds that the respondent state has violated the applicant's right to fair trial, protected under Article 7.1d of the Charter, with regards to the right to be tried within a reasonable time. The court finds that the respondent state has violated the applicant's right to a fair trial under Article 7 sub 1 of the Charter, with regard to the non-consideration by the High Court of the medical evaluation report regarding the applicant's mental health status at the time of commission of the offense. The court also finds that the respondent state has violated the right to life under Article 4 of the Charter in relation to the mandatory imposition of the death penalty. The court finds that the respondent state has violated the right to the respect of dignity under Article 5 of the Charter in relation to the method of execution of the death penalty, that is by hanging. Unanimously on reparation, particularly on pecuniary reparation, the court dismisses the applicant's prayer for material damages. The court equally dismisses the applicant's prayer for damage for moral prejudice suffered by alleged indirect victims. The court grants the applicant's prayer for damages for the moral prejudice he suffered and awards him the sum of Tanzania shillings 5 million. The court orders the respondent state to pay the sum awarded, as read above, free from tax as fair compensation to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears, calculated on the basis of the applicable rate of the Central Bank of Tanzania, throughout the period of delayed payment until the amount is fully paid. On non-pecuniary reparation, the court orders the respondent state to take all necessary measures through its internal processes and within 1 year of the notification of this judgment to reopen and finalize the criminal proceedings relating to the applicant through a procedure that does not allow the mandatory imposition of the death sentence and oppose the full discretion of the judicial officer. The court also orders the respondent state to immediately take all necessary steps to remove the mandatory imposition of the death penalty from its penal code, as it infringes on the discretion of the judicial officers in imposing sentences. The court also orders the respondent state to publish these judgments upon notification thereof on the websites of the judiciary and the Ministry of Constitutional and Legal Affairs, and to ensure that the judgment remains accessible for at least 1 year after the date of such publication. On implementation and reporting, the court orders the respondent state to submit to it within 6 months from the date of notification of this judgment, a report on the status of implementation of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On cost, the court orders that each party shall bear its own cost. This judgment is signed by the bench as earlier mentioned, and it is done at Arusha this 10th day of January in the year 2022 in English and French, the English text being authoritative. In accordance with Article 28(7) of the protocol and Rule 70 of the rules, the declaration of Justice Blaise CHIKAYA, the Vice President, and the joint declaration of Justice Ben Kiyoko and Tijaline Aro CHIZUMILA are appended to this judgment. Thank you, Mr. President.
La Cour a ainsi décidé. Merci, Justice ANUKAM. Ainsi s'achève le prononcé prévu cette matinée par la Cour. Je redonne la parole au greffe de la Cour.
Merci beaucoup, honorable vice-président. Merci beaucoup, honorable de la Cour. Donc, ainsi prend fin le prononcé de l'arrêt. Je pense que, comme vous le savez, après cela, nous avons la réunion du comité d'audit. Donc, on va peut-être